Thank you very much. Thank you very much, Florelia. Thank you very much, Giorgio, and thank you very much, Mattia, for the invitation to be here today and present. Let me share my presentation. Can you all see it? Yeah?
Yes,
Yes. Not from the first one, sorry. I think some glitch. Yeah? Can you see the first slide? Yeah?
Yes.
Perfect.
Yes.
Okay. So my presentation, I have the honor and the duty of being the first speaker today. So I'll try to also have some kind of introduction into the topic of hate speech. I'm sure everyone here is very much familiar with what hate speech is, but of course, being the first one to start a conversation, I will have I will need to introduce a little bit the topic. But what I'm going to discuss today is a focus on online content moderation. So not from the perspective of the social media platforms, but from the perspective of users that are looking at social media platforms and looking at how they decide to moderate content and moderate hate speech, and whether that is compliant with international human rights law, and more importantly, what could be, as a sort of like opportunity for improvement, the role of multi-level governance. So first of all, I'm going to give a little bit of introduction to content moderation. What are the problems of content moderation, and in particular, issues related to definitions of hate speech, both in international human rights law and in content moderation settings. Then how does content moderation works in the context of hate speech? And where the issues may arise in balancing freedom of expression and protection of the rights of others, and therefore prevention of extremization and extremist and polarization speech. And again, like, so kind of like summing up, what are the human rights challenges of content moderation in terms of balancing of rights? And then what could be the role, if any, of a multi-level governance for online hate speech? And I will define that later. Content moderation. What is content moderation? We all very much know what it is, but it is important to kind of like draw some initial common points. So it's that process through which social media platforms decide what content stays and what content is removed from their platforms, and is a kind of like a process with different steps and different elements, and each of them define what content will stay, what content will be removed, and each of these steps can be problematic from a human rights perspective, and in each and every step we can have a more or less tension between the different rights at stake. So of course the content moderation is very much based on the guidelines, the platform guidelines. Could be the community standards, the internal guidelines, the terms of references, but also on the guidelines that may be given by national or supranational legislation. We have now in the EU the DSA that actually adds new content and new responsibilities upon platforms, together with the code of conduct. In particular, when we talk about hate speech, the code of conduct on hate speech, we have the one on disinformation, and we have a lot of national legislation as well. Thinking of the German legislation, the Swedish one, the UK one, that are adding new level of grounds on which the content moderation should operate. Then we have the second part, that is the flagging part. So what type of content gets flagged, gets identified as possible, either illegal or harmful. And here is where, again, like another layer where, of course, this is based on the guidelines and on the definitions given in the guidelines of what content is allowed on the platform. But the step of how we identify and with what level of precision we identify that content then leads to what content then is then removed or not. How this is done? Through different tools. We can use AI tools, so automatic tools to flag content. We rely on users that may report content, but we also rely on third party, and this is something that's been further strengthened by the EU DSA on the role of third party flaggers and trusted flaggers for flagging content. Once the content is flagged, then it goes to the decision point. And that is where all the theory of international human rights law comes into play. How do we balance rights? And that is like the topic of today. How do we balance freedom of expression with the protection of rights of others and prevention of polarization, harmful content, hate speech, as well as extremism? How this is done, again, that is the problem. We're going to discuss it later. It's done either by the same AI tools, automated tools, or is done by human moderators, or a combination of the two. And then there may be different decisions that can be taken. The content can be removed, the content can be confirmed on the platform, can be demoted, or there may be just a warning on the content, like it happens with what is possibly considered false information, with a warning saying that may be false. But another very important part of the content moderation process is the notification and appeal. So once the decision is made, especially if the decision is removal, demotion, or warning, then the user should be notified. And the user should have the possibility to appeal to that decision through very open and strong judicial and non-judicial avenues. This is very much often a problem, as we will see later. There may be options like the metaverse sideboard as a sort of like Supreme Court internal to the social media platforms, but also we cannot forget the role of national courts, national judiciary as an ultimate kind of arbiter of what can and should not be online. So throughout all these, all this stage presents issues from a human rights law perspective, have been heavily criticized, but also discussed by international human rights law scholars, practitioners at the UN level. The UN Special Rapporteur on Freedom of Expression, both the current and the previous, have largely addressed those issues and trying to support social media companies in improving all these steps of the process. Because the point of content moderation, and again, it links to the topic of today, is a continuous stressful balance between keeping the content and removing the content for somehow, very good reasons in any way. Of course, the content, social media platforms are pushed to remove the content because of the human rights obligation under the UNGPs. They do have human rights obligations to preserve, to respect human rights on their platforms. They also have legal obligations under national and supranational law. Let's think about in the European space with the recent EU DSA, but again, also under lots of different national laws. They are obliged to remove content that is flagged and identified as illegal or falling within certain kind of categories. So they have a legal obligation to do so. They also have to remove content to keep the platform safe, because they keep saying that they want their platform to be safe, also so somehow to keep the users active and engaged with this sense of like safety on the platform, but also to avoid extremist speech and polarization. And in the kind of like increasing role of platforms as democratic square for public debate, it's important to keep the platforms. It's important for the platforms to not contribute to extremist speech and polarization. On the other hand, they are also pushed to keep the content, both for economic reason and for somehow more idealistic one. So, of course, we know that one of the reasons why platforms may be willing to keep the most violent and harmful and sometimes disgusting content is because it increases visualization. And this is linked to their business model that is based on advertisements. That is, again, based on visualization and engagement, users' engagement. So we know that the business model is kind of like working against the decision of companies to remove content. Companies are also encouraged to keep the content because some users do use these platforms because they know that they can express themselves freely. And so increasing removal of the content on the platforms may lead some of these users to leave the platforms. And we saw, especially in the US, this kind of like change, for example, with Twitter, now that it became X, and the policy of X has becoming more and more toward freedom of expression rather than moderating content, and it has attracted more users that were otherwise pushed to alternative platforms where they could say whatever they wanted. But also, I think, and this is very important from our perspective as international human rights lawyer, is that one of the reasons why they are pushed to keep content is because we told them so much about the importance of freedom of expression. So since we are so concerned about, and rightly so, about the fact that too much content moderation may lead to censorship, because of course we don't trust the process, we don't trust how the decision is made, and again, we will discuss this later, we push them to restrict the content. But then at the same time, we tell them, if you restrict too much content, then you're going to curb too much freedom of expression. So they sometimes decide not to remove content because they want to preserve freedom of expression and because they were told to do so. And so even from a human rights perspective, sometimes we give social media platforms kind of contrasting opinions and contrasting indications. But this is, in a way, the nature of international human rights law, and has always been this way with balancing of rights and freedom of expression versus competing rights and interests. But the issue, and I will delve into that later, is that in the offline context, we do trust the process, we do trust who takes the decision, who's usually a judge in a court of law. And so this kind of delicate balancing of freedom of expression versus rights of others is very much it is addressed in a way that we trust and we appreciate. Sometimes we don't agree, but in any way we respect the process. When it comes to content moderation, the ways in which content moderation is made makes this contrasting indication sometimes complicated, when especially is left to the decision of an automated system or a human moderator without the skills and expertise to take such a delicate decision. So against all this background, we even have an additional level of complexity, that is that of that we're not talking about simply something that is easy to define. We're talking about hate speech. Hate speech is extremely complex to tackle even and to define even outside the online space, even offline. And that is one of the main reasons why addressing hate speech online is absolutely impossible to do in the right way so far, or at least has been quite impossible to do in the right way. The problem is who decides what is hateful. Hate speech is one of the most subjective expression in international human rights law. And as we all know, there is no international agreed legal definition of hate speech. We have plenty of definitions in international, in regional, and in national human rights and non-human rights instruments. But all these definitions differ for some kind of like wording or expressions, which is not too much. If we read all these definitions, they're not completely different, but there are some differences in words used and expressions that make it possible to interpret them in completely different ways. And this is because if we ask in a room if anyone knows what hate speech is, the answer is always yes. Everyone knows what hate speech is. And everyone, say like the majority of the people would be also very keen in saying, yes, hate speech should be prohibited, should be addressed strongly. But if we ask in a room of 20 people, what do you think hate speech is? We will probably get 20 different definitions. And this is what happens in the international human rights law framework. So one of the latest definitions of hate speech is that the one provided by the UN Plan of Action, which is a very great definition, very comprehensive, including any kind of communication in speech, writing, or behavior that attacks or uses pejorative or discriminatory language with reference to a person or a group on the basis of who they are, or on the other words, based on their religion, ethnicity, nationality, race, color, descent, gender, or other identity factor. This is a great definition, but it's great if we have to use it in a policy setting, if we have to prepare and organize awareness campaign or policy interventions. It's not so great if we think that on the basis of this definition, we are going to restrict a fundamental right that is freedom of expression. Because then we can clearly see how broad and vague it is. It's true that we do have the Rabat Plan of Action, where we have some more information and guidance on how to identify the worst type of hate speech, the illegal hate speech that should be criminalized, looking at elements such as the context, the speaker, the intent, the content, the form, likelihood, and imminence. But again, applying those elements into specific situation and instance, it's really difficult without an extensive knowledge of the context, the speaker, the intent. All these elements should be very much familiar to the person that makes the call to being able to identify where the hate speech sits, or where that speech sits in the spectrum of hate speech. And even the EU DSA does not define what illegal content is, and there are lots of obligations upon platforms to remove swiftly the content that is what is defined as illegal content. But the DSA says, oh, I'm not going to define hate speech. I'm going to refer to relevant EU and national laws. And what is interesting is that EU and national laws not always align when it comes to defining what hate speech is. And what I have here is a sort of like spectrum of different type of speech. And if we agree that like the extreme hate speech, that is incitement to violence and genocide, absolutely need to be removed from a platform, what about the annoying speech? The annoying speech that it is protected by international human rights law, and rightly so. We know that through all the extensive case law of regional human rights courts and the UN Human Rights Committee. But we also know that due to how content works online, a cumulative effect may happen, in the sense that a lot of annoying speech targeted against a certain group may lead to harmful consequences, even more harmful than one single post that is extreme hate speech. How do we tackle this? And what I think like the problem of the international human rights law community when we talk to social media platforms is also that we need to develop a little bit more clarity on where do we want platforms to intervene, and what different types of measures do we want them to put in place for each of these types of content? Because if we agree that yes, they should remove those that are more on the higher side of the spectrum, what do they have to do with the harmful but legal and with the annoying speech? Because there is where very much the balance between freedom of expression and what may happen in terms of extremization and polarization is key. So do we want them to remove that annoying speech if is the hundreds of in a series, but how do we establish when the threshold is met of that kind of like cumulative effect? Also, because in international human rights law, there is an obligation to remove hate speech. We know Article 20 of the ICCPR prohibits any advocacy of national, racial, and religious hatred that constitute incitement to discrimination, hostility, or violence, and that is what we consider as the core of hate speech prohibition. But we also know, and that is to be bear in mind that the US put a reservation to that due to the tradition of the United States as being so much pro freedom of expression. And most of the social media platforms that we are discussing today are US-based platforms, so they may be influenced by the US approach to freedom of expression and also Article 20 ICCPR. Addressing hate speech is also an obligation under Article 4 of the International Convention on Elimination of All Forms of Racial Discrimination, even if here the definition of hate speech is slightly different from what we saw before, because it's very much focused, of course, on racial discrimination. And we also know that addressing and restricting hate speech, prohibiting hate speech and restricting freedom of expression is allowed by Article 19, paragraph 3 of ICCPR and Article 10, paragraph 2 of ECHR. But the debate on whether we should or we should not prohibit hate speech is still an ongoing one, and we have plenty of scholars that that take one or the other position. Even if I believe in the last decade, more scholars have kind of like milded their opinion into, yes, we should address it, let's decide how, but there are very few voices right now that says, no, we don't have to do anything, and we should keep all the speech out there, even though the discussion on whether good speech may overcome the bad speech, it's still something that we hear from businessmen and CEO of big platforms very often. Again, like looking at the international human rights law approach, we do have a lot of nuance in terms of hate speech and hateful content and harmful content. And this is taken from Article 19, the NGO Article 19, kind of like pyramid of hate. And depending on the severity of harm, we expect states to take different approaches and different measures. The problem is that this is like meant for states, is meant for state authorities. Do we expect the same kind of like approach from platforms or not? And if we then agree that what is there must be restricted part that should be regulated through criminal liability, should be addressed by social media companies with full removal, what about the lawful but harmful hate speech that we expect for like standards and transparency requirements, where these again can lead to extremization, can lead to very harmful consequences? How do we address those? Are they completely, do we address them offline maybe, and the online space should not be touched? Or are we expecting companies to do something? And I don't have an answer to that. I have just a lot of questions. So now we look at how social media platforms are taking these definitions. And while in international human rights law, we try to kind of like, have a different nuances, have different steps and shades of harm, depending on the severity. We see that social media platforms definition are very much more cross-cut, and they are very much more direct without many of these shades. I'm not going to read all the three definitions, you can do so, but what is interesting here is that they are different. I mean, like Facebook and X are really similar, but the categories, the protected characteristics are different in, for example, Facebook and YouTube, and they're quite like arbitrary in the sense of like what protected characteristics they pick. In YouTube, we have age, while for Facebook, we have serious disease. How did they come up with that? And as we see, this is not like an open-ending list. It's a very exhaustive list. There is not any other status. They're just this list of protected characteristics, which is very interesting on how they came up with them. And they, in a lot of conversation with social media platforms, they told us that they are continuously reviewing, and indeed they add caste a few years ago as an additional characteristic. But again, on what basis? And it usually is a responsive action to what is happening in the world. But why do they come with this list, and do they not mirror what is in, for example, the UN Plan of Action? What is also very important is that there are not much more explanation. There is this definition, and then there are specific examples of what constitutes or does not constitute hate speech. But this very much is so much vague. It's vague even for an expert on hate speech, which makes it even harder for someone who's not an expert in the topic to apply this to a specific piece of content. So if we look, for example, at the Facebook definition, when we say that we define attacks as violent or dehumanizing speech, harmful stereotypes, statements of inferiority, expression of contempt, disgust, or dismissal. What is a harmful stereotypes? Who decides what is harmful stereotypes? This may assume that there are not harmful stereotypes, and who makes that call? And dehumanizing speech and violence, the level of violence and what we understand as violence is very much subjective. So yeah, all these three approaches and definitions are very problematic from a human rights law perspective, because they are very general, vague. They do not mirror the international human rights law ones, even though, again, there is not an agreed. If there was an agreed definition in international human rights law, we could have blamed them not to mirror that. And indeed, the response of platforms is, in international human rights law, you don't have a common definition. So how can we take just one? But the problem is that they're very vague and very subjective, and there is just a set of examples rather than more explanation of the meaning of the terms. However, even with this very broad definition, everything could be fine if we trusted who applies those definitions into the specific context of assessing a piece of content. The problem is that we are very skeptical about who takes the decision. And here we go into the practical functioning of online content moderation, because those definitions are then operationalized and then used by automated tools and human moderators to make the call on each piece of content on whether the content falls within that definition and therefore should be removed or not. So automated systems. At the beginning of, I remember when I started working on this almost 7 years ago, we were all very shocked by the use of automated systems, saying we don't want automated tools to decide what content stays in, and so AI judges to decide what is a good or a bad content. However, if we look at the reality of things, it's normal that we use online automated tools. It's normal due to the amount of content that is shared online and the speed and the geographical scope. So we can really not do without automated tools. And as we see, this is like some very up-to-date, I took them from yesterday, data that the DSA shared from the transparency reporting of social media platforms about the amount of automated detection and automated decision. So if we see, like, when there is automatic detection in the 67% of the cases, there is also an automated decision. So when the because what the automated tools do is that they automatically flag content that is suspected content as either illegal, harmful, or in general not compliant with the internal guidance or terms of reference. And when there is content is labeled with a certain degree of certainty and level of confidence, then can be automatically removed. And that is what is happening in the 67% of the cases, which is very much worrying sometimes, because if we think back to that definition, how that definition can be operationalized and how can the definition then be applied to the specific content is usually by keywords. But the keywords may not, even though natural language processing is improving every month, it's still not at the level where automated tools can identify sarcasm, jokes, poetry, or even factor in issues such as context, history, and culture, which means that they can lead to both under restriction and over restriction. So they may miss completely some very, very bad hate speech and harmful speech content. They may overly restrict something that is absolutely not amounting to hate speech at all, but may contain that keywords that were considered as, or that pattern of words that is considered as hateful. And also the degree of certainty of these automated systems it's very much debatable. So the capacity of these automated tools to make this call, especially on such a complicated and subjective issue, is very much under discussion. Luckily, we do have also human moderators, and sometimes we are relieved when we know that the content is then reviewed by human moderators. The human moderators can both flag the content and review the content that is flagged and then take a decision. The problem is that there are not enough human moderators. And we know that the number of human moderators is important because we need a lot of people to check all the content. And on X, when Twitter became X and changed leadership, and a lot of decisions in terms of policy were made, including firing a lot of people from the content moderation team, this led to an increase of harmful content on the platform. There is also a completely lack of hate speech expertise. We know that there are some human moderators who they know very much about the topic, but there are also a lot of people who are completely oblivious about this. And what they know is what the guidelines and the internal definitions are. They're very expert on the internal definitions, but they don't understand the nuance of the problem. And they also have to work on so many posts and so many content that they cannot really take too much time for each of them to think about the context, all the elements of the robust plan of action to make a call. There is also a lack of language expertise, and the DSA transparency reports really shed some terrible news about how little knowledge about language that are not the English, French, and Spanish languages among human moderators. We know that human moderators with expertise in even Arabic are very few. And if we think about other languages, less spoken languages, sometimes it's like none of them speaks that language. So they rely on automated tools to translate, which adds another level of complexity. And also the lack of context expertise. They do not know, and they cannot know everything about the context, the history, and the culture, the specific context in all the countries in the world where, or even the communities where the posts are uploaded and they concern. So, on the basis of that, do we think that are they able to strike a fair balance between freedom of expression and competing rights and interests? And do we trust them? Do we trust those human moderators in taking the call? We do trust a judge in a court of law because we trust them in their expertise and knowledge. Do we trust human moderators? Sometimes not so much, or maybe we can improve the process. Lastly, and I know probably my time is coming to an end, the last part of the procedures, the content moderation is the part of procedures and appeal, because even if we don't think that automated tools and human moderators are doing a foolproof job, and I mean, they're doing what they can, but there are a lot of flaws. We still believe that, and we still are hopeful because there is a procedure for appeal. And this is like one of the tenets of international human rights law, having the possibility to appeal and get redress. And this is what should happen. Users should be notified and should be able to appeal to the decision. The problem is that oftentimes users are not notified, but most importantly, they are not given any reasons on why their content was removed. And when they try to appeal the decision, the process gets very complex and sometimes completely ineffective. The DSA demands effective appeal procedures and dispute settlement options, both non-judicial within the companies and judicial, bringing to courts. But we still have to see how social media platforms are putting this in place. We have some examples of initiatives such as the Meta Oversight Board, but the question is whether what they're doing is effective enough, considering that the amount of content they should review and the limited resources and also time that they have at their disposal, and having a global body that has to overview everything. Of course, like they only focus on some examples and some representative cases. And also there are like a lot of debate on whether their recommendations to Meta and to the platform have been effective, since Meta has not really taken on board many of their recommendations. So among this, then there are a lot of like outstanding challenges when it comes to moderating online hate speech. And all of that presents issues from a human rights perspective, from the procedures of content moderation itself, the definitions, the issues of balancing of rights and interests, which is already complex in offline, even more online, the tension between the local context and the need to understand the local context versus the global scope of online content, the use of automated systems and how well they are able to incorporate these definitions and make this delicate call. The issues of appeals and remedies not effective at the moment, and all the issues about liability and accountability, who should be accountable for both harmful content that stays on the platforms, but also for a wrongful removal of the content. So to address all that, and I'm coming to the last part of my presentation, I believe, and this is something I'm currently working on, I believe there may be an avenue for improving part of these issues and challenges. And that could be resorting to a multi-level governance for hate speech. We realize that online hate speech can't be addressed only by social media platforms centrally, due to all the elements we just discussed. There is a strong need for a deep knowledge of the context, the language, and the international human rights law standards that social media platforms in their current formation and with their current structure, they do not have. Both the DSA and the UN Plan of Action on Hate Speech, but also the recent UNESCO guidelines on platforms governance, suggest that social media platforms should engage more and more with third-party actors to carry out content moderation to address hateful or illegal content. The point is, who are these third parties? Who should be these third parties? A lot of focus has been put on NGOs, which absolutely play a pivotal role in advancing human rights compliance. But what I suggest here is focusing also on some other actors, and that are what I call local human rights bodies. So national human rights institutions, NHRIS. So all this plethora of 172 National Human Rights Commission, Ombudsman, and other independent national human rights institutions, which are not NGOs, but they are established by the state, but independent from them. And they have been worked extensively on hate speech related things. Of course, they differ country by country, but globally, they have been working recently on online harmful content, and some specific national human rights institutions, such as the South African Commission, have worked specifically on defining hate speech in the specific country context, coming up with a list of keywords that in that specific country may be red flags for hate speech, which is something that could be extremely beneficial and is what is missing for social media companies to improve those definitions and enable more precise content moderation in the specific local context. Also, regional human rights systems may play a key role. We know the Council of Europe is very much on top of things and is working quite extensively now with AI and human rights, but also on hate speech. But also the African Union and the Organization of the American States are slowly working more and more on online hate as well. The African Commission of Human Rights is working on a resolution on this as well. And this will help additionally to provide further definitions and context and knowledge. but also the UN field mission and the UN Special Rapporteur's country missions. We can see in the UN Special Rapporteur's country missions reports some specific details about what are the forms of hate speech, of harmful speech in the specific country context, which is absolutely key to make content moderation effective. And the same way, UN field missions, so both peacekeeping and peace building missions, can be extremely important in both flagging situations where hate speech may further rise or providing further context. And that is what also the UN Plan of Action has been focusing on with a dedicated report. So how these bodies can help content moderation and improve the tackling of online hate speech? I think that in 4 different ways. The first is improving definition. As I said, lots of these bodies, they provide specific definition that are linked to the context of that country, of that community, and therefore could support the automated systems, the human moderators that are working on posts uploaded from that country or concerning that country to use a more nuanced and more detailed definition of what hate speech means there. Flagging potential risky situation in context of upcoming elections, social unrest, or situation where more hate speech can arise. The flagging and this is very much linked to the DSA trusted flaggers role. So flagging potential risky situation is absolutely important because it means that the companies should pay more attention to those situations and watch them out more closely and pay more attention, therefore reducing the level of harm on the platform. And then once the content is flagged, all those bodies and those institutions may also collaborate with social media platforms to provide expert advice in the reviewing process. So in the very delicate balancing act between freedom of expression and competing rights and interest, and also informing human moderators on the context and the country-specific language. And then lastly, there could be a role for them in supporting appeal procedures and access to remedies, which could be in a way decentralized and therefore more effective because then accessible to more people. Of course, this is in a way a wishful thinking and more work should be done because, of course, while a multi-level governance approach is getting traction in different way across systems, there is the real need of real commitment of political will and resources, because of course all these human rights institutions do not have the resources to do this job for free. They will need to be supported financially by the social media platforms. So there should be a real commitment from the tech company side to fund this collaboration. But this could be a way in which we can regain trust in the process of content moderation by not outsourcing, but collaborating with human rights institutions at the national, regional, and international level that we trust in a sense of expertise and knowledge on how to draw this very fine line between freedom of expression and competing rights. Because otherwise, I mean, even though like this issue, the problem of balancing and how to tackle hate speech and harmful speech is a never-ending problem, both online and offline. Online, we can do something more. We can do something more if we bring in institutions and that we may trust and that we may consider apt to the task. But the issue at the end of the day is that will content moderation ever work in addressing hate speech? I don't know. And that is probably a question for the debate. Thank you very much.